practical secrets that will save you time and trouble. And I'm also hopefully going to open your eyes to some of the opportunities you have to really protect yourself without and not spend too much money. Okay, I'm going to wait one more minute. It's just right at the top of the hour, 60 more seconds, and we're ready to go. While we're doing that, I'm going to tell you a little bit about myself. Most of you know me. In fact, a good number of you have been represented by me. But those of you who don't know me, I have been doing nothing but asset protection for the last 20 years, 22 years. I've written 3 major books on the topic of asset protection or international tax that have been published by real major publishers like Times Mirror Corporation, Matthew Bender, Warren Gorman, Lamont. I've taught at USC Law and Business Schools for more than 6 years, where I was a tenure track professor. I've taught at NYU, just a few courses, a few classes, Loyola, Marymount, a whole bunch of different law schools. I have more law degrees than I can count, 3, but I don't practice law. What I do is protect people from lawyers, and my greatest joy in the world is when a lawyer comes after my client and doesn't walk away with anything but a big bill. Okay, I'm going to start. Here we go. Today, I'm going to be talking about what the perfect asset protection plan looks like. And I'm going to be doing this from the point of view of somebody who doesn't really have a lot of knowledge. I'm going to assume that this is your first shot at really considering asset protection, so I'm going to start at a pretty low level, and I hope that it will help you. What is asset protection, or what asset protection is? Bad grammar. I wrote that. Asset protection is more of a state of mind, and the reason I put this slide up is I wanted to make a pitch that you take 10% of the time you spend making money protecting it. That will result in you keeping a lot more of your money when you become an older man like me. I'm 63. And if you spend a little bit of your time worrying about keeping your money, you will. And there's many different types of asset protection. It isn't just some fancy plan involving offshore trust companies and tons of money in paper. There are many, many, many types of asset protection decisions you make in your daily life. The decision to not drive when you've had too much to drink. The decision to walk away from a potential fight. Or there's, they break into, but they all break into statutory and non-statutory. Statutory asset protection are the types of asset protection that your senators and congressmen or your state legislatures have decided to give you. Here they are. The types of asset protection that are statutory are primarily ERISA. ERISA is what keeps O.J. Simpson in the pink, so to speak, although he's, I think, still in jail. Probably will spend the rest of his life in jail, but he's got to keep the money, even though we all believe, at least I believe, that he murdered 2 people. ERISA is great asset protection. So is, or so are IRAs. IRAs aren't 100% effective. IRAs are dependent upon state law, and they can sometimes be pierced, and they are not all protected in bankruptcy like ERISA plans normally are, but they are still really great. And another type of statutory asset protection are homestead statutes. Guys, you can do all these things for nearly free. Wherever you live, in every state, there's some sort of homestead protection. It can be real cruddy like it is in California, or it can be really great like it is in Texas or Florida. But your home in many states is your castle, and in even states that don't have great homestead laws, they have what's called tenancy by the entirety laws, which can, in at least 13 states, give you tremendous protection. These are based upon statute. This means the government protects you. Another statutory protection would be charging order protection with LLCs and partnerships. That's not part of this conversation. Another one would be the bankruptcy exceptions. In bankruptcy, you get to keep certain assets no matter what happens to you, no matter how bad your financial situation is. So those are typical statutory provisions. And I know I'm moving fast, I'm moving at the speed of light, but this will be recorded. You will be able to listen to it again. And All of these are meant to stimulate your brain, not turn you into an expert. Non-statutory asset protection is what I do. It's what I think all of you should be thinking about if you've got two nickels to rub together, because there are lots of case law and more complicated situations that really will protect you and your family from the attacks that come out of nowhere, or the attacks that come from your best friends, or the attacks that come from your wife or your husband or your business partner or your children or your brother or your neighbor. It seems like a lot of the attacks come from people who are close to you, not people who are far away. And most of the non-statutory asset protection rules depend upon my first two rules of asset protection. I'm like Gibbs on NCIS. I have a whole string of Rob's rules. Like Rule 4 is always carry a knife if you watch NCIS. Well, Rule 1 is the first and most important rule of asset protection is what you do not own cannot be taken from you. What you do not own cannot be taken from you. Sounds simple, sounds stupid. It's pretty hard to get in your brain now. If you don't own something, it can't be taken from you. That doesn't mean you can't control it. That doesn't mean you can't benefit from it. That doesn't mean it can't be a G5 that you travel the world in. But if you don't own it, it can't be taken from you, even though you're enjoying it every single day of your life. So first rule, what you do not own cannot be taken from you. By the way, I'm thinking of doing a seminar on Rob's rules. If you'd be interested, let me know. It's something that is kind of cute for me, but it also helps me keep myself on the straight and narrow. Second rule, no country in the world automatically enforces U.S. judgments. No country in the world automatically enforces U.S. judgments. Simple, silly to say almost, but it's true. Some little court in California or New York or Texas or Nebraska puts a judgment against you for $1 million, and you're living or you've chosen to make your financial presence in another part of the world. They might not even know where Nebraska is, and even if they do, they certainly don't care what some Superior Court or Supreme Court judge in Nebraska says. That judgment isn't normally worth the powder, the paper it's written on in most other countries. By the way, not true with arbitration awards. Always be careful. Mr. Martin Domke, one of my mentors who died about 20 years ago, founded the American Arbitration Association, and he made, by virtue of lots of statutory efforts, many countries adopt statutes allowing U.S. arbitration awards to be enforced abroad. So never agree to arbitration in a contract. The non-statutory provisions, though, basically rely upon those two rules. What you do not own cannot be taken from you, and no country in the world automatically enforces U.S. judgments. This will make more sense as I move ahead. Starting point for a perfect plan. The starting point for a perfect plan is almost always a trust. Why? Because a trust can be designed to satisfy the first rule, which is what you don't own can't be taken from you. You can make it so that a trust is an artificial person, and that if you give stuff that you want to protect to a trust, and the act of giving it's not a fraudulent conveyance, a quick aside, but you give stuff to a trust that you want to protect, it is no longer yours. You've satisfied the first rule of asset protection, which is what you do not own cannot be taken from you. And a trust is just a bucket. A trust is an agreement between a person called the settlor who gives something to a trustee and says, will you hold this and do with this as I instruct you? It could be as simple as, hey, trustee Bill, here's a gold Rolex watch. Will you give it to my older son when he graduates from UCLA Law School, which he just did about 5 years ago? And if he doesn't, will you give it to my younger son? And then if he doesn't, will you sell it and give it to the poor? That's a trust. That trustee, George, I think, in my example, has a fiduciary duty to me, the settlor. My kids are the beneficiaries. that's as fancy a trust as some of the 100-page trusts I do. It's just as much a trust anyway. Now, one thing you can see, as I say here, a trust will normally, if it's done right, take your assets off your balance sheet. If you take your assets off your balance sheet, you no longer own it. You satisfy the first rule, which is what you don't own cannot be taken from you. But remember, excuse me, there is no such thing as a one-size-fits-all trust. That's something I'm going to be dealing with a little bit later in this, because I think that I've created some trusts that are almost universal, almost fit everybody, but in reality, all trusts really should be made specifically for your personal situation. It is not a it's not a cookie cutter situation for most people, and I'll be talking about that in detail near the end. Now, what fancy provisions are in typical asset protection trusts? Well, this is a list of the main ones. First one is the trust is often foreign. That means it's fancy, but that means you have to have a foreign trust company or a foreign trustee, a human being. It can be a human being or a trust company. To make it foreign triggers some sophisticated tax issues you have to deal with, like offshore bank accounts need to be disclosed, and if it's a foreign trust, a 3520 type of tax return needs to be filed. It doesn't create any tax liability. None of this will create any tax liability, but there are some reporting requirements required. But the first provision that most trusts that have asset protection features is that contain is that it's foreign. And another aside, domestic asset protection is a crock. There is no such thing as a viable domestic asset protection trust. 13 states so far have them. None of them work. They've only one that's been challenged in court was ineffective to protect money. It's because the full faith and credit clause of the U.S. Constitution. Any judgment in any state has to be enforced in every other state. It's in the federal Constitution, which trumps any stupid little state law. So that's just a quick aside on foreign versus domestic. It's why I strongly urge you to stay away from the touters of domestic asset protection trusts. They do not work, and if you ever do go with them, you make sure, here's a little hint that makes the whole seminar worth it, make sure that they write you a letter on their legal stationery telling you that it's going to work, telling you that the full faith and credit clause does not trump their Alaska statute. Get that, and then make sure they show you that they're insured. At the very least, you have an insurance company standing behind the loss you're about to have if you're attacked. Another thing they all have is duress clauses. A duress clause it's often called freedom from outside interference. A duress clause is a clause that I always laugh about because it's the hardest thing to write. The trust that I traditionally use has had at least 420 law firms go over the duress clause. Every time they do it, they throw their hands up. Why? Because you're essentially telling a judge to take a hike. You're saying, if the judge orders you to do something under duress, I'm instructing the trustee to ignore what the judge says. That's a duress clause. Now, if you say that, you're going to piss the judge off, so you spend 10 pages or 2 pages or 10 sentences trying to make it so that you have disenfranchised the judge without pissing him off. It's kind of an art form. I pretty well mastered it, and most good asset protection practitioners have mastered it, but it's the big difficult clause to master in an asset protection trust. The next one is a Cuba clause. A Cuba clause, by the way, we've been at war essentially with Cuba since 1962. I can't stand it. I'm going to go there next month and finally visit it and come back with a load of Cuban cigars. But we've been unfriendly to that little country since 1962. So they call it a Cuba clause, and a Cuba clause is an automatic migration provision. It used to be automatic anyway, where the trust would automatically move from one jurisdiction to another if attacked. Well, now anybody who does it carefully does not have them as automatic, because if you have them automatic, you can't ever classify your offshore trust as domestic for tax purposes. So they usually require a decision by the trustee to move. But a Cuba clause allows the trust to move. And by moving the trust, you change the playground. You change the sandbox. You change the rules. If you have a trust in Cuba, which no, there are no trust companies in Cuba. I've checked that. But if you had a trust in, say, England, and you were being attacked in England, then you move that trust to St. Lucia or moved it to Belize, that trust would have a whole different set of laws. And the people attacking it in England would all of a sudden find that they had to find new lawyers, and they had to go to new jurisdictions. And oops, just like England, they had to pay the lawyers a great big retainer. No such thing as contingent fee litigation outside of the United States. So the Cuba clause is a mighty potent weapon. And remember, anytime you can make somebody have to spend $10 to collect 10 cents, you've created a pretty good plan. There is no such thing as a perfect plan. You're going to find out that next month I'm going to be showing you how to pierce plans. Well, sometimes it's economical to pierce a plan because they're all pierceable if you have enough money and if you have the right facts. But they're almost impenetrable if done right, and you keep the structure so that they're very expensive to pierce. Another thing that most asset protection trusts have that regular trusts don't have is a protector. A protector is your buddy. A protector is a naysayer. A protector has no ability to do anything, but just has the ability to say no. And it's very common to say the trustee may, comma, with the written consent of the protector, comma, invest in, shrimp operations or whatever you want to do. The protector oftentimes is put in a position of having to okay major important activities by a trustee. And it's a good way to have a secondary level of protection and a watchdog over the actions of the trust without you, the settlor client, having to be in control of the trust. And the less control you have, the safer you are. You want to control, though, you want to control everything. You have to control your money, but the less overt control you have, the better. So if we can keep you out of the formal driver's seat but still in control, you're in the best of both worlds, and you'll start to see that in a little while. All
Rob,
trusts that yes, sir.
Rob, hi, this is Tony. just want to interrupt for a moment. One of our listeners has called in, and they're tapping or typing or something. And I just wanted to ask if you could please, if you're on a phone that you can mute, if you could mute your phone, or if you could stop tapping or typing, because it's distracting on my end. I'm sure that it may be distracting to other listeners. So I just want to ask that courtesy, please, if whoever's called in and is typing, or it sounds like typing on the line, if you could mute your phone or just cease the typing activity, that would be great for everyone else. Thank you so much. Rob, sorry to interrupt you.
Oh, no, thank you, Tony. The back to excluded parties. Most of my trusts have a player called excluded party. An excluded party is a person who is specifically identified as not able to be benefited by the trust. And this would be a person who's constantly after you, or a class of people. Like, it's so common for my clients with beautiful young daughters to say that their husbands are excluded parties until they've been married to their daughters for a certain period of time, and the older the parents are, the longer the period of time is. But all of you with young, beautiful women getting married have that same feeling. I'm sure you do if you have beautiful men getting married. My son just got married, and I had my first grandson. Wow, 3 months ago now. So anyway, that's something that you don't see in traditional trusts. And mostly with an asset protection trust, you get to choose the playground. You get to choose the laws that apply. You can hunt for great jurisdictions, but I can tell you that all jurisdictions are better than the United States because there is no such thing as an international full faith and credit clause. The full faith and credit clause is only for United States, only in the United States. No other country in the world, rule two of Rob's rules, enforces U.S. judgments. So by choosing a trust in a jurisdiction that any jurisdiction, you're miles ahead than having the trust in the United States, and you have the option to choose trusts in several countries that have really serious laws that make it really expensive and difficult for creditors to attack in those countries. The best laws are primarily the Cook Islands and Belize, but I actually love several other countries just as much. You're going to find that the capacity to pick and choose the playground is a major power if there's ever a problem. And another thing you can sometimes look at is it costs about 2 hours of work to move a trust from jurisdiction A to jurisdiction B. It might take 4 hours of work. It might even take 6 hours of work. But it takes 60 or 600 hours of work for a creditor to uproot himself from jurisdiction A and move to jurisdiction B. They have to hire a new lawyer. They have to pay a new lawyer. They have to learn a new set of laws. It is just an awful problem. And that is one of the major weapons that you have if you do an asset protection trust to discourage people from ever coming after you. It's an effective rule. And these are things that should be in all trusts, no matter who does them, no matter where they're done, no matter when. Okay, what are the 4 parts to a perfect plan? The first part is the trust I just talked about. I'm going to show you a diagram in a minute which will help. But the other parts are an offshore limited liability company. Notice I didn't say offshore IBC. I said, or International Business Corporation. I said offshore limited liability company. And I'll explain that when I get to that. Third part is an offshore bank account. You need a place to put your stuff. And when I say bank account, I don't just mean a place to put money. Most offshore banks that are materially powerful banks have many other services they provide, including custody assets, even hard assets such as gold and silver sometimes. The fourth part is an onshore family limited partnership. That's what FLP means, or LLC, limited liability company. I will talk about that when I get to it in about 10 minutes, but the onshore family limited partnership, or LLC, is not necessarily appropriate in all cases. I only do them for about 1/3 of my clients. If you're a doctor, if you're an orthopedic surgeon living in Delaware and you're licensed in Delaware and you can't even work once you're outside of Delaware, and all your assets and everything have been in Delaware, and all your investments and friends and everything are in Delaware, you might want to keep your money at Bank of America in Delaware. I can't think of a worse place. But you might want to keep your money at Bank of America in Delaware, in which case we would put your money into a family limited partnership or limited liability company, and I'll explain the difference and the reasons for each later, and have that owned by your offshore trust. It is feasible to put your domestic assets under the protection of an offshore trust, but that is not typical. Something happened to the phone. Anyway, that's not typical for my clients to do, and it's not something that I encourage them. Now let me show you the first diagram. I think this will help. This is the first step of an asset protection trust. See the little blue and purple bucket? That's my best effort at drawing a bucket. That is an asset protection trust. I put APT so you can see it. There's a little lightning bolt in the middle of the page. To the right of the lightning bolt is offshore. To the left of the lightning bolt is everything in the United States. And everything in the United States is much less protected than everything to the right of the lightning bolt, which is offshore. And you can see three little people. The red one is a settlor. That's normally the client. That's you. That's the person that forms the trust. The settlor is important because the settlor can never be fired. It's the only player in this whole structure that is there for life. You can never be removed from being the settlor. And as settlor, you retain the power to change or fire the trust company at any time. That may be, in some cases, the only power you ever have at the trust level, which is to change the trust company. If you see trouble coming down the road, that's the best type of setup you can have. As little control as possible over the assets of the trust company at this stage. You'll see why that won't matter in a little while. But you have the settlor, the red person. That's normally you, and that is normally, if you've got a really carefully done trust, the only major power you will have. See that little yellow square called trust company? That's the foreign trust company. You always need to have an offshore trust company to do an offshore trust. It can be a human being in countries, but I hate to trust a human. At least with offshore trust companies, in almost every country, they've had to go through a very sincerely comprehensive licensing process. They normally are owned by the wealthier people in the country. They normally are under governmental review because the countries don't want to be stuck with crooks and thieves. So they have very sincerely intense review processes for trust companies. And a good trust company will have its own internal procedures to keep it on the straight and narrow. I like trust companies that refuse to take your money. I try to get my clients to not deal with the trust companies that are used to managing their money. Coots and Company, Queen Elizabeth's company, or Cox and Wilkerson. Those are both great trust companies. I can name 15 of them. Royal Bank of Scotland's a great trust company. They will do asset protection trust, but they want 1% of your assets under management. Even if they don't manage it, that's their fee. And if you're a billionaire or a millionaire, it's a really lot of money just to pay somebody to watch you manage your own money. So I like to pick trust companies that are licensed by the government, not individuals, but don't insist upon controlling or managing your money. And in fact, many trust companies won't even ask you what you have. They will verify that you're a straight shooter. They'll verify that your funds are after-tax dollars. They'll require letters from lawyers and accountants proving to their satisfaction that you are on the straight and narrow, but they don't care about what you own. If you own dinar, if you own Swiss currency, if you own gold bullion, or you own pleasure boats or airplanes, they don't care, and they don't even want to know. And that's the best type of trust company to choose. See that little yellow guy? That's the protector. Sometimes that's also the client. Usually it's a different person if there's any trouble in the winds. If there's no trouble in the winds, it is even appropriate to have the settlor client be the protector. That is perfectly fine. And by the way, guys, I'm in Belize right now, and the thunder has just started thundering. They could turn off the internet. I hope they don't, but if they do, I will complete this at a later date. Let's just keep our fingers crossed. Below the settlor and protector is a little blue guy. These are the beneficiaries. The beneficiaries are typically the settlor. If the settlor is a husband and wife, it'll be both the husband and the wife. And then it usually will be their kids. And if their kids are dead, it'll usually be another group or a charity, or it can be anything. But normally an asset protection trust has a list of beneficiaries. It normally does not try to be your estate planning document. Using sophisticated but very simple power of appointment provisions that any estate planner is just totally comfortable with. If you're not comfortable with them, you don't need to be, because you're not going to be writing your own will. But when you do your will or you do your estate planning trust, you will find that it is very simple to have your will or estate planning trust control the disposition of protected assets. Now, I've sort of scurried through this quickly, but I wanted to let you know that this is the key element, this offshore trust. It satisfies the first rule of asset protection, which is what you don't own cannot be taken from you, because it takes the assets that are put into it off of your balance sheet. And it satisfies the second rule of asset protection, which is no country in the world automatically enforces U.S. judgments. This is the starting point. This is the engine that drives it. The only problem is that all the control at this level is with that little yellow box, the trust company. So we have to do something to get that little yellow box, trust company, out of control. And here's what we do. We put in an offshore limited liability company. This has become the best way to do it. In the old days, when I kind of invented what's called kinetic trusts, we would put the settlor as a co-trustee with the trust company, because you have to keep control of your money. You have to stay in control. You don't want to trust anybody with your money. More important than all Rob's rules together is my main rule: trust nobody, assume everybody's a crook. Assume your trust company's a crook. They won't be a crook if you go to one of the good ones. They're highly regulated, but just assume they're crooks. And by assuming they're crooks, you never have to trust them with your assets unless you decide to. And that's the situation you want to be in. So the best way to get that result is to put in that little triangle, an offshore LLC, limited liability company. It can be, it's just a nothing type of entity, but it's got all the same powers and relevance and separate entity status. That's the actual term of art in the Caribbean, entity status, as a human being. It is a brand new baby. The trust and the LLC are brand new babies that the settlor has birthed. And the only thing that's good about this LLC is, first of all, banks are comfortable with LLCs. Most of them in places like Europe, where, except in England, where they are used to trusts, France, Germany, Holland, most of the rest of the world is based upon the Germanic system, statutory law. It's code laws from the Napoleonic Code, and they're not used to trusts. So offshore trusts are a little bit more difficult to open bank accounts, but offshore limited liability companies somehow slide through like a hot knife through butter compared to trusts. So you have an offshore limited liability company that, here's the real beauty, it is managed by that little red guy. That little red guy happens to be you, the settlor, the client, husband and wife, or husband or wife, or whoever you are. This is where you keep yourself in control. Remember my overriding principle, trust no one? Well, this is where you open your bank accounts. This is where you manage your life. The little red guy controls the offshore LLC. And if it has money or real estate or gold or owns 100 different McDonald's franchises around the world, including in the United States, it is managed by you. It is managed by the settlor client, who happens to be the manager of the offshore limited liability company. That way you, the human being, stay in control of your money at all stages, period, end of report. And that is really critically important, more important than anything else. Now I'm going to just push the next little button and show you the third step. And this is all that most of my clients ever do, unless they're the doctor, the orthopedic surgeon in Delaware, who just insists on keeping his money at Bank of America. Honestly, he can find banks that are 10 times or at least double or triple the strength of a Bank of America just by moving out of the United States. So many clients, and I think I actually am very worried about where America is going. I'm seeing de facto exchange controls starting to take place at Chase Bank, and Wells Fargo just told me that wiring money is going to really cost a lot more. Starting to stop stop the easy transfer internationally of funds. So I want my money out of the country and in safer environments. But this is your decision. But here's what the typical third step in any traditional asset protection plan is. The third step is opening up an offshore bank account with a bank of your choice. I think one of the most important things for you to do is to get an offshore bank account. I oftentimes recommend, and you're going to find I'm going to recommend to you a trust company and a country in a little while. Most of you already know what it is, Belize. I like to help clients, or have the trust company help clients get bank accounts, because they're candidly capable of doing it. Getting a bank account is actually harder than doing the whole asset protection plans anymore. It used to be that planning was like doing brain surgery. Now I've done so many, it's become routine. But getting a bank account is no longer routine. FACTA and all the rules and troubles that the government has put on these banks has made it so that many of them don't even want U.S. clients. I was speaking with the general counsel of one of the major banks in Belize a few months ago, and he told me that his bank was spending more than $250,000 a year for the honor of keeping U.S. citizens and complying with FACTA. Well, that's not a big deal if you're J.P. Morgan. I mean, if you're ABA AMRO Bank in Holland and have $30 billion or $300 billion of U.S. deposits, but if you're a little teeny bank in a little teeny country, that's a killer. Anyway, you can open up offshore bank accounts. They can be also offshore securities accounts. They can be offshore repositories. When I say bank account, I mean entity that'll hold your stuff. And you can go in all the currencies of the world. There are different rules at every institution. Some institutions won't even take you unless you're depositing 15 or 20 million of dollars to start. Others will start you with just a few $1,000s as a deposit. And you need to get started. One of the first ways to enter the offshore asset protection world is to get a good account, get it wherever you can with a decent bank of your choice, and you always make this choice yourself. And then live with it. Make it work. Get a good reference from a good international bank. That is the key to opening up the second and third account. That's the key to moving into the bigger banks and the more diverse banks. And you'll have to start small depending on your size. But this is the perfect asset protection plan. You're looking at it now. I'm going to add the fourth step. That's the doctor, the orthopedic surgeon I described. He would form a domestic family limited partnership or an LLC. I would usually use Delaware. Delaware has the best laws, but you sometimes have to go to the law of their state if they're engaged in a trade or business. It's not worth trying to use Delaware because states like California or New York or New Jersey will require that you qualify to do business, so you might as well spend the outrageous fees and form a domestic entity in the place that your doctor is doing business. But the good part is in all of these, you have that little red guy who happens to be the same as the settlor. You have that little red guy, here he is again right here, this little red guy. You have that little red guy, it's also the same as the settlor, this little red guy here. It's you. You stay in control of your money. Never let this trust company be in control. Never let that happen. You stay in control. That's you here and you here and you here. This settlor doesn't actually exercise control, but it happens to be the same person. This is the perfect plan. Now, I'm going to add or do this card just to do a 1 or 2 minute overview on this family limited partnership. Sometimes you will use a limited liability company. Limited liability companies are simpler, they're newer entities, they're cheaper to form. The problem is you're really doing this entity here to separate ownership, which you want to be with the trust, 99% to 100% ownership, zero control with the trust. You want ownership to be with the trust, but control to be with you, the general partner or manager of the LLC. Sometimes you do an LLC, see that? But you will only I like partnerships better than LLCs for domestic use. My reason for liking partnerships better than LLCs for domestic use is that the separation of ownership from control is statutory in the partnership laws of every state. The statutes say that the limited partner, which is this trust, the limited partner has no say-so in the management of the partnership. And if you have just an LLC, you're relying upon good drafting. I don't care how good of a draftsman you are. Nobody can pay me enough. You can pay me $1 million. I still can't draft better than it's in the statute in Delaware that this trust can't control this thing. And if this trust can't control this LLC, or excuse me, this partnership, then this trust can't be sued for the torts that this partnership has committed. That's why I like partnerships better at this level, but LLCs do work. This is the perfect plan diagram. These are the 4 parts. You can see them. Take a screenshot if you can. You will get to see the review of this webinar whenever you want. But this is it. I don't care whether you spend no money or $1 million. You can't get any better than this for a straight-ahead asset protection plan. Yes, there's 100 combinations and permutations, but this is the key nuts and bolts basics that you need to have. And in my mind, I would always leave this part out, this domestic part out, unless there was a real need to have it. But it's pretty easy to add. This is the hard part. The foreign part is the key parts that you have to make this domestic part even work. Now, what a perfect plan is not. Well, I just went into a long diatribe 15 minutes ago why a domestic asset protection trust is a piece of garbage. Just accept that. Trust me. No, don't trust even me, but I'm right on that one. You can research it, pay your lawyers, and check it out. A standalone LLC or family limited partnership. I get asked this question all the time. Why don't I just do an LLC? There's charging order protection. Bill Reed, who just went to jail last week for 9 years, high time, and a few others started this bunch of bull that you could rely upon charging order protection to shield your money from creditors. It's been abused for so many years that it just plain doesn't work very well anymore. It's not a good way to do it. Why? Because you always remain the owner of the LLC or the family limited partnership. The standalone LLC or family limited partnership remains owned by you. You didn't trigger the first rule of asset protection, which is what you don't own cannot be taken from you. If you don't put it into an offshore or even an onshore trust, although you'll get crappy asset protection, it still stays on your balance sheet. You want it off your balance sheet. And the reason you want a foreign trust is so you can trigger Rule 2, which is no country in the world automatically enforces U.S. judgments. An asset protection plan is not your standard estate plan. Look at that. It's really important. I'm serious about that. It is not your standard estate plan. Your standard estate plan says what happens to your stuff when you die. It says who takes care of your kids if you die. It says who feeds you if you become a vegetable. It does not deal with protection of your assets. Your estate plan deals with protection of yourself and distribution of assets. So always combine your estate plan with your asset protection plan. Let your estate plan control the disposition of the protected assets. I'll repeat that. Let your estate plan control the disposition of protected assets. And finally, note that a perfect plan is not insurance. Insurance and asset protection go together. A lot of people say, make me judgment proof. Well, that's bull. First of all, over-aggressive asset protection can quickly become a fraudulent conveyance. But even so, asset protection is not a substitute for insurance. The main reason is that a good insurance policy gets you a defense. A defense is what you always need. It's sometimes more expensive to pay the lawyers if you're sued than it is to pay the judgments. Keep insurance and asset protection. How to implement your own plan? Well, that's one of the things I promised. I'd give you some tools that what you needed to do or think about. All planning starts with educating yourself. Get your brain straight. Figure out the rules. Learn the rules. You can go watch all of my videos. You can hire asset protection experts. You can read good books. Ryan Fowler has a great book. It's available at Asset Protection Training. I have 3 very good books. Um, get yourself educated. Stay off the hands of the scammers, and I'll show you how to find scammers. But asset protection really is going to break into 2 different segments for those of you watching this video or this webinar. Some of you will want a do-it-yourself plan. That is not the best way to do it. That satisfies about 70% of the people, though. And the reason this exists is I let a preacher down about 20 years ago when I told him I would not do asset protection for him because I'd never done a plan for less than $24,500, and I wouldn't take, and that was about 10% or so of his net worth, I wouldn't let him spend that much. And he lost everything in the next year when he ran over somebody at night and injured them. He wasn't protected, and I refused to protect him. And I think every single person out there, whether you have $20,000 or $200 million, deserves and needs asset protection. We live in a very litigious society, and now I'd say even dangerous as the litigiousness is the fact I think our society is starting to fall apart. We can't afford our bills, and we all saw last week that if you turn off food stamps for 2 hours, you have 2 Walmarts being burned down. The police had to come and stop it. That is where America is going. And if we can't make our bills, we're going to have civil unrest, and you're going to be really grateful you've done some asset protection if you do. The do-it-yourself asset protection, if that's your mode, and this is where my heart is and where my focus has been, because I've been working with a trust company called Mayfair Trust Company for the last year, trying to help them increase their marketing reach. You can go to AssetProtectionTraining.com /plan. You can see the link right here. It's the do-it-yourself AssetProtectionTraining.com /plan. You can go there and you can actually get a plan that is a very good model for a person who has no problems, mostly money, a couple $100,000, up to a million-ish, no problems, no sophisticated issues, no tax problems, not walking any fraudulent conveyance issues. You can do that, and I believe strongly in my heart that you are 1,000 times better off having asset protection in place than being stuck in gridlock, not able to move ahead because you're afraid that what you're going to do is either a fraudulent conveyance or is too complicated or too expensive for you, or you can't spend the $20,000 or the $10,000 or whatever the asset protection experts quote you to help you. And there aren't many asset protection experts, guys, less than 20 in the whole country. There's a lot of masqueraders, but you'll learn that when you check references. If you don't do it yourself, you're going to hire an expert. I'm one of those. There are several others, and you will always get a custom approach with whomever you go to that's good. They will charge you several $1,000s. Somewhere between $6 and $30 would be a typical fee, depending upon how complicated you are. That's almost always worth it. I think it's worth it. It's how I make my living. But if you can't afford to do that, you shouldn't afford to hire me, then you sure should not go into gridlock. You are miles ahead to take care of yourself. Spruce the plan up 2 years from now when you got yourself back on your feet. But don't let yourself be a sitting duck while you sit there fearful to move. You can do asset protection on the low-cost basis by doing it yourself, just like you can build your own home. It's a lot of work, and you probably won't have all the lines. The walls won't maybe be as perfectly straight and square, but you'll at least have a roof over your head. In all cases, this is important. Run like crazy if they promise to save you taxes. No, asset protection will save you taxes. You can do tax planning with asset protection, but a lot of the scammers promise to save you taxes. the second that comes out of their mouth, run. Second, run if they say your bank account is secret. There is no such thing as a secret bank account. All you have to do is read what the NSA has been doing. And I've been saying this for a decade and a half. There is no such thing as a secret bank account. If you have one, declare it. You're going to jail if you don't. Or at least you're going to be talking with an agent, probably with a gun on his side, because the CID, Criminal Investigatory Division of the IRS, carries guns. Don't get in that mess. Don't fall for it. There is no such thing as a secret bank account. Run. Run like hell if anybody seeks control over your assets or says, trust me, this is my problem with Panamanian foundations and all the people that say, give me your money, Bill Reed, give me your money, and I will keep it safe for you. We'll put it in a bearer shares. I'll hold the bearer shares. You don't have to worry. That's a bunch of crap. If it sounds too good, it is too good. Always run if it sounds too good to be true. And always, 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 the last point, involve your lawyer, involve your CPA, involve whoever your financial advisor is. If you don't have one, get one. Trust companies are not your advisors. If you do it yourself, realize trust companies do what they're told by professionals. And trust companies will give you documents, at least Mayfair will, because they've been trained to do that. And they've developed a great set of documents that'll save you 20 grand if you're a right person for it. But involve your local lawyer, involve your local CPA. It shouldn't take more than an hour or two of work by somebody sophisticated to make sure you're not being sold a pile of garbage. And you won't be being sold a pile of garbage if you do any of the things I suggest to you. But don't trust me. Trust somebody who lives 20 minutes from you and has an office and goes to Rotary and uses the same Ford dealer to fix his tires or her tires. Hire somebody local to help you and to be your eyes and ears, a second opinion. Next month's webinar, and this is just 1 minute, is going to be on the 21st. That's a Thursday at the same time. It's on attacking asset protection plans. Paul Brown and maybe a couple other lawyers who successfully defend and attack plans are going to be there. Paul has torn apart some very major hitters. I hope he'll be able to mention it. I've been involved with him a little bit. I'm a switch hitter. I like to tear other people's plans apart more than I like to even do them. It's really exciting to take poor technology and help my clients' creditors to profit from it. The same banks that I'm disenfranchising all the time are glad to hire me to go pierce plans. Anyway, we're going to be talking about that. Even if you're not after somebody, it's a good way to get an idea about what a good plan should look like and how to insulate yourself from these attacks, because actually asset protection is as much game theory as it is anything else. Now, we're on to question and answers. We have 7 minutes. Well, I took a little bit longer than I thought, but if there are any questions, I can't see them. I've just
Rob,
been talking.
I have some questions that have been submitted. This is Tony.
Yes, sir.
And first of all, I want to let everyone know that if you look over in the chat screen there, you'll see a URL. It's AssetProtectionTraining.com /plan. And you can go look at that link later on today, and you'll see exactly what Rob was talking about with the type of do-it-yourself plan. This is really, Rob, I want to make sure I understand, this is the same like $20,000 technology type of plan, except it's not custom from the ground up. They're getting the same type of technology they would normally pay $20,000 and upwards for, except some of it's kind of turnkey and it's going to save them a lot of time and effort. Is that correct?
Yes, they're just not getting the hand-holding, and they don't have somebody on call to say, well, you're absolutely right. That's how it works. Let me call the president of this or that. You're not getting the hand-holding, but it's the same structure. You can't do any better. This isn't like we're selling you half of a software program and you can activate the rest by the payment of 20 grand. You're getting the full Monty here.
All right, so I'm going to get to some of the questions that were submitted. Jeff asked about how the current FBAR and FACTA laws, especially for 2014, are going to affect offshore asset protection trusts. Well,
they're going to make it really harder and harder to get bank accounts. Jeff's probably already found that if he goes into um, an offshore bank right now in his own name, there's few and far between that they're going to just take him as a client. It's not going to change it much from now, because I've always assumed from every waking moment that everything you do offshore is perfectly transparent to the Internal Revenue Service, and that's really what these laws do. But they've made it so that several securities houses, for example, have recently told my clients to go find another securities house. They don't want U.S. customers. They're small enough they can't afford the $250,000 hit to annual cost of compliance. And FBAR is just an overreaching activity by the United States. It's making it more difficult for U.S. citizens to move their money abroad, which is exactly what people like Obama are happy to have you do. They'd rather you keep your money in the United States and buy government bonds so they can use their money to give it away. Ooh,
and so
goodness,
for
did I sound bad?
well,
Sorry.
I think that we're all on the webinar to hear your opinion, Rob. So give it to us straight. So is the bank account that's offered by Mayfair a good solution for someone like that?
It's usually the only solution. It's a good starting spot. Mayfair offers a bank account in Belize, with right now the major bank of Belize, the biggest bank in Belize. The bank has 24% reserve requirements, which I think is pretty neat. $24 out of 100 are in the central bank in U.S. greenbacks. I don't know how good those greenbacks are, but I'll tell you what, that's 22% more reserve requirements than Chase Bank has. Chase and Bank of America and Wells have their reserve requirements in their ATMs. It's down to, I think, 2% right now. That's how much their money is in their ATMs. We don't even have reserve requirements in the United States. Our banking system, after the insurance, is absolutely perilous.
So do you still recommend Belize Bank International for individuals?
Yes, oh, of course I do, because it's a good bank. They take care of you, but there's many good banks. I think the people should decide on their own banks and go to wherever they can get one. It's just that Mayfair has the capacity to help them with what's the first bank account they need. It's like getting a good Kia. Well, maybe you're used to driving a BMW, but when Kias first came out, they were considered less of a car. But I'll tell you what, they go places, they get there. Yeah, it might bump a little bit more. And yes, I'm not pleased always with the customer service. And yes, they are on Belize time. They don't really work as fast as you do, as you're used to having your bankers and your lawyers and your accountants jump through hoops when you call them. But they get the job done, they keep your money safe, and it's the key to getting the type of protection you need in the long run. If you want a major Swiss bank, it's a whole lot easier to go there after you've had 2 years experience with a major Caribbean bank, where you can get a great reference.
Well, I think that the recommendation of selecting your own bank is good, but it's important to me knowing that you've already vetted this bank in Belize, because trying to research and find a good bank for someone who doesn't have any expertise in that area is difficult. So it's good to know that you actually recommend that as a solid bank. One other question that came in.
I bank there.
Well, there you go. We had Deborah asked that she's attended a couple of your seminars now, and she wanted to know if you had any other suggestions on what to do if you have no family or anyone else to put in your FLP. What other options are available?
Well, all you need is yourself, Deborah. All you need to do is you are the general partner, and your trust is the limited partner. You don't need anybody else. Period. You've got the whole kit and caboodle right there.
Great, thank you. Hilton asked, during a lawsuit, is it okay to transfer real estate into an LLC so a creditor can only get charging lien, or will that be considered a fraudulent conveyance?
Oh, well, what's his name, Tony?
Hilton.
Hilton, first of all, don't count on charging order protection ever from an LLC, particularly if you're transferring assets to it in the middle of litigation. that is marginal protection at best, and traditionally won't work. And is it a fraudulent conveyance? You can count on them arguing it is, and that's. But it's only a fraudulent conveyance if you're rendering yourself unable to meet your reasonably anticipated debts, or if you're doing something to abuse, defraud, hinder a creditor. And there's plenty of ways to justify transactions like that for estate planning and other reasons. This is something you can't really answer on a telephone call. This is something for you to take up with your local litigator and your local estate planner. Transferring assets to an LLC alone, though, is just amateur hour, defective, mediocre, and pretty piss poor asset protection. You said I could say. You could said I could say what I wanted to say.
Yeah, absolutely, absolutely. So another question we had. Joe asked, can the beneficiary of a trust be another trust with different beneficiaries in the primary?
Oh, of course. No, that's commonly done. And one of the greatest things people do is when their kids start to grow up, rather than keep things in one trust, so kid Joe can fight with son Joe can fight with daughter Sally about Sally needs the money for her, whatever she does. She's a failing artist, but needs money for her $2,000 a day loft in New York City. And the son wants to keep his money. He's an investment banker in Kansas, and all he does is want it to grow at 1% at Chase Bank. And they're fighting over the money. It's very common to split the trusts up, or to actually flow the money into two different trusts, so the daughter can go spend her money and deplete it for her artist loft in New York, and the investment banker can keep his money growing at 1%. They don't have to fight. So yes, subtrusts and sibling trusts are very common and very helpful.
Great. One of our attendees has asked about the $50,000 cash deposit that a creditor needs to come up with in Belize. Can you explain briefly how that works?
Oh, well, in Belize, if you do a Belizean limited liability company, it requires for a creditor to attack that company in a Belizean court, the creditor is required to post cash, not a bond, but cash dollars, greenbacks, in dollar bills, not a promise, not a letter of credit, not a bond from an insurance company. He's required to go into this little white building in downtown Belize City and walk up to this lady who is a very nice lady. I've met her a number of times, and actually deposit good hold cash with her. You can write her a check that'll clear in a day, or dollar bills as the price of actually bringing an action. You have to put up 50 cents on the dollar for every dollar you want to recover. So if you claim that Joe Blow, the manager of a Belizean LLC, somehow owes you $1 million, you're going to have to put up $500,000 just to raise the issue. And that's on top of already having to pay your lawyers in cash, because there's no such thing as contingent fee litigation, and pay the travel costs and pay all the horribly expensive logistical issues you have to overcome to even bring the action in the first place. So Belizean LLCs are a major impediment to creditor activity. It's a great part of an asset protection plan. I didn't talk about that because I didn't really want to focus in on Belize. Belize is my favorite jurisdiction, actually, from the legal point of view. The Cook Islands and Belize both have good laws. Belize laws are a lot easier to deal with because they're on U.S. time zones and they are more available. Belize has more than 50 decent trust companies, while the Cooks have 7, and there's no competition there. I like Belize better from the logistical point of view, but they both have great laws.
Great, thank you. Another question from Conrad. Can stocks or real estate purchased in or from the USA be transferred to the LLC or offshore trust?
Yes, it is more common to put it into the LLC. And Conrad, sometimes you would even use the domestic, like the Delaware Family Limited Partnership I pointed out. If you were in a good situation where your life wasn't falling apart, you might just put those apartments that are, say, in Kansas City, each one in its own LLC, and have that LLC owned by a Delaware Family Limited Partnership that was owned by the trust. That would be part 4 of the plan I just described. That way, if trouble ever comes, and remember, you've got 2 or 3 years, trouble never happens overnight. Trouble happens with letters and lawyer letters and threats and pushing and calling, and then they start swearing at you, and a year later they sue you. It gives you time to sell those apartment houses and transfer the money abroad upstream to the accounts in the offshore LLC. The offshore LLC is where you want the money to end up when the trouble happens.
Great. So we have another question from Olga, and Olga, I think, has taken a look at what is being offered with the do-it-yourself plan, and she says she likes the idea of an offshore trust and bank account, but without a tax consultant to work with that's familiar with the trust, she wonders, isn't that kind of like purchasing a car without a set of keys? Will we be able to have a team of professionals to work with?
Olga, if you want to hire to do a do-it-yourself asset protection plan, which is really great quality, it's a great asset protection documentation, it will probably fit most people's needs. You need to reach into your pocket and get yourself a decent local CPA, a decent local lawyer. You cannot depend upon a trust company to provide you with U.S. tax and legal advice. You need to hire a local, and I am happy, and Mayfair is happy to recommend qualified CPAs, but you're going to have to either do an awful lot of reading and become educated to do it yourself, all of it yourself, or you're going to have to pay an accountant a few $100 or a few $1,000 if you get complicated to handle your tax issues. They are the same whether you spend $100,000 for a trust or get it for free with Mayfair. The tax issues are the same, and you need a good tax accountant. You don't ever want to play fast and loose with Uncle Sam.
Rob, another question that came in, which kind of ties into what you answered a few minutes ago, was about fraudulent conveyances. Is there a time frame in which you have transferred assets that is no longer considered fraudulent?
Well, that's a good question, and I'd like to answer it, but I'd like to answer a different question first and then answer that.
Okay.
Normally, with a fraudulent conveyance, here's how I do it. I have many people come to me after they're in trouble. And let's just say they've got easy numbers. They have $1 million, but they've been sued by their neighbor, and their lawyer says the worst case is they're going to lose 100 grand here. Well, normally the average person will say, I'm scared, I can't do asset protection planning. I will take that person and I will plan and I will protect $900,000 of that person's net worth. I will leave $100,000 of unprotected assets behind. Ideally, I will leave that $100,000 in something like a polluted oil field or something that's not as attractive as money in Bank of America,
right?
Which is easy to get to. But I want to fear of fraudulent conveyancing should not stop your planning. You probably need expert help, but don't get into gridlock. Getting stalled can hurt you much worse than moving ahead either with a do-it-yourself plan or an expert-done plan. That's the best thing. Now, the next part was, oh, Tony, you'll have to ask it to me again. My brain.
Is there a time frame in which you've transferred assets no longer considered fraudulent?
Okay, most states have a 7-year fraud statute of limitations. Most states, realistically, the statute of limitations on fraudulent conveyancing is 4 years, because you're normally not going to be engaging in actual fraud. It would just be they claimed it was a fraudulent conveyance, and they won't be able to prove you had an intent to. It's hard to prove actual fraud. 4 years is a relatively safe period. If you have an old and cold plan, do it now, and 4 years later they finally decide to get rambunctious, you probably will have a decent statute of limitations bar on a fraudulent conveyance claim. Old and cold really helps. Old and cold is good. Older and colder a plan is, the better it stands up.
Here's another one that's I think is kind of interesting. Is John asked, as a settler, can you get a salary from the trust for advisor fees?
Oh, of course, and you should. I can
No,
talk more about it, but yeah, yes.
that's pretty straightforward. Um, so
And also from the LLC. You can do the same from the LLC. And also, you should manage your own money, sir. Anytime a client hires somebody else to manage their money, I get calls 2 years later about how dissatisfied they were about the returns and the fees and what a mess it was. And I always urge my clients to take control of their own assets. Control your own assets enough so that nobody can take them away from you. And if you lose money, it's your fault, not anybody else's.
great, Rob. This one came in from someone that's marked unknown. Talk about choosing a trust company. How do you choose a trust company? You recommend Mayfair, but how would a person choose a trust company?
They go to an expert advisor and they ask, and then they check some references, probably. It's pretty hard to choose a trust company because they're all, every trust company will make different promises and have different standards. I can tell you Mayfair is a New York City type trust company. When they tell you they're going to do something today, it happens today. They don't have dissatisfied clients because they function on New York standards and New York time. That's not true with many places in the world. Um, it's very, very difficult. You have to trust an expert, and then you have to trust your gut. And remember, any well-done plan lets you fire a trust company in 2 minutes. So if they don't satisfy you, you fire them and get another one. That's not an excuse not to do planning. If you're worried about your trust company, it's not like you're getting married to her.
So the real key here is not the trust company, it's the plan.
Yes, the plan
Yeah.
is what's key. The trust company is just one of the major ingredients. They're renting you their country. The way I do planning, you're not trusting the trust company to manage your money or to control your life. So candidly, as long as they answer the phone and are there to register your trust, you're pretty well got what you need. That's why in my cases they can keep their fees so low, because honestly, after the first year, they're not doing very much other than maintaining your government file, satisfying the government that they have minimum capital requirements, and satisfying all of the junk, which is a lot of junk, that trust companies have to do to satisfy the governments that regulate them. It's a big deal to be a trust company, and the governments extract a pound of flesh, both in fees and in compliance. They don't want junky trust companies. Almost every country has basically good trust companies. That's something you can pretty well count on if they're registered with the government. In almost every country that requires that, they're going to be decent people that have put their life savings and their lives on the line to form these entities. And then don't go with a trust company that wants to control your money. If they want to control your money, move on. You won't be dissatisfied that way. Your biggest exposure will be the 4 hours it takes to fire them and hire another one.
And Rob, when you say ask an expert, my judgment is that most of the people on this webinar are looking to you as that expert, and you are recommending Mayfair. So in 30 years in this field, what is it about Mayfair that makes you so keen on them?
They do their work quickly and professionally. Mayfair is owned by local law families and is intent upon becoming the best trust company in the whole world. They understand asset protection. They're not intent. In fact, they will not engage in, they will not manage people's money. They will not even take clients' money, which I love. And that was a criteria for me to agree to work with them when they asked me. I don't want trust companies that want millions of dollars of my clients' money. That's the recipe for fraud and temptation and problems in these little countries. It is much better for your money to be with a major bank that you feel comfortable with under your control and your signature power, period. and you just use your trust company to rent their laws, and you pay them a few dollars for that honor. That's all. And you want them to pick up the phone when you call them. That wasn't a very good answer. I just happen to like them.
Oh, that's a great answer. Here's another question. Dealing with Belize, Kristen asks, and I know that you already have your money there and things, so this should be very easy for you to answer. But Kristen asks, how long do you feel Belize will be able to be such a safe haven when they're so small and being hit with the fee to basically protect U.S. citizens?
With the fee to protect U.S. citizens? I couldn't understand that word. Hit with
yes, it says the fee to basically protect U.S. citizens.
Oh, I mean the costs of complying with the U.S. laws. Oh, well, that's not going to change. They've done it the first 2 years. They're going to keep doing it because it's profitable for them. Belize is just a little country, 320,000 people. I don't think the Belizean banking system is anywhere near as strong as any country in Europe except Cyprus, and Cyprus is much weaker. But it's not Switzerland, guys. It's not Liechtenstein. It's not Holland. If you can get a bank account there, great. You can't get a asset protection trust over there, so it doesn't matter. Most people, when they get really rich, have only a little bit of money in Belize and have their money in 4 or 5 other banks in 4 or 5 other countries. They might have $1 million in Belize and the rest of their money in 8 other countries. That's perfect. But I'm assuming most of you aren't multi-gazillionaires, and Belize is perfectly good for $1 million, $2 million type of deposit. And if Belize starts to get shaky, by then you'll have the reputation with the banks to be able to move it. Just don't
Great.
move it back to the United States.
Thank you. Here's an interesting question. How does one handle assets not held in a trust that need some level of protection, mainly financial assets?
Well, that's a very difficult question to come up with anything more than I've said today, because you've gotten the best of my brain. You either do statutory or non-statutory asset protection. You don't put it into an LLC and rely upon charging order and some BS from some website that you're going to be protected. That's gobbledygook. You don't do a domestic asset protection plan. That's double gobbledygook. You do an offshore asset protection plan if it's financial assets, and if you can't include them in there for some reason, then they're exposed unless they're in ERISA plans, or unless they're in a home that is homesteaded properly, or unless they're in an IRA in a state where IRAs are protected. And you know, there's not an infinite list of solutions out there. You either protect your money with an offshore plan or put it in an ERISA qualified plan, or consider it partially exposed. And don't fall for charging order protection in an LLC, and don't fall for domestic asset protection.
Got it. Bonnie asked the question, and maybe she's brand new to the field of asset protection, but her question is, what are we supposed to protect our assets from?
Honey, read the newspaper. There's no way I can even begin. I'll go on a 10-minute diatribe of how the United States is falling apart, how litigation is rampant, how you can't even, in the United States, you can't, you're going to get sued for everything you do. One of the big jokes in Belize is, yesterday in a restaurant, I saw somebody fall. They didn't really hurt themselves, and everybody helped them, and they took them over to the first aid clinic, and they got a stitch. Well, they were all laughing about how if it was in a restaurant in the United States, there'd be a lawsuit coming tomorrow. Well, we know there won't be a lawsuit in Belize, because there's actually, even if they sue, they're going to just give you the $22 it costs to get sewed up. I mean, I'm sorry, but America's a dangerous place, falling apart. Last week, when the food stamp cards were turned off, 2 Walmarts were under siege, got ready to be burned down. I actually think that was an experiment by the government using Xerox, which handles those credit cards. But you know what? That's what we can expect, I believe. And we have more than 100,000 new lawyers coming out every single year, with most of them not being properly employed. They have nothing else to do but sue people, and we're the only country where they can sue people on a contingent fee basis. Hence all of the telephone and television ads. Hey, has your such and such fallen off because you ate a green pill? Well, if you've
Right.
lost your whatchamacallit, call us because we want to sue everybody for you. What other part of the world does that happen? The answer, no place.
Rob, and I think another thing is that it's not necessarily if you do something that may cause a lawsuit, but oftentimes it is simply if people notice that you have assets, if you have wealth. I have a good friend who's a real estate investor who about 3 years ago was sued, and I was actually in part of this non-legal meeting where the lawyers for the suing party basically told him, said, look, we know you haven't done anything wrong. We know that you are operating above board, but we don't give a shit. We're going to sue you anyway.
That's so
that is
typical, Tony.
Yeah.
That's my world.
That's exactly what he said to him, and I couldn't believe it. And my friend actually settled with them instead of the expenses and everything going to court, simply to avoid it, because this was a mad dog attorney. So if you have assets and people are aware that you have something, there are people that out there that want to take it from you. You don't have to wait until you do something that might cause liability. Simply because you have wealth in any stretch of the form, there's people out there that are going to want to take it because they feel entitled.
Well,
So
one of my clients, he's the builder of the first compact computer, became an extremely wealthy household name sort of guy. And in one of his facilities in Newport Beach, he was visiting it, and he saw a little worker, a Hispanic man, out getting some food at that little food truck was outside. And he tripped, and he hurt his ankle. My client took the man to the hospital and actually gave him $500, $600 when he took him home after he'd been, just reached into his pocket, said, oh, they became friendly with him. The next day, my client was sued 7 times for slip and falls. The rest, before the end of the week, he had 7 lawsuits from people who worked for him. He had a lot of employees. Things like that happen. We live in a country, the United States, where it is considered normal to go shake people down. I don't trust or have respect for lawyers anymore, because if I have enough money, I can hire almost anyone to do anything I want, period. From the biggest firms to the littlest firms. And the integrity is gone. It is all a money game, and it's sickening, but it's the way it is. And if you don't protect yourself, you are just being selfish and uncaring to your own family. That is how I feel about it. We do live in a place where it's become lawless like it used to be in the Wild West. The legal community simply is not ruled by honor and integrity. It is ruled by finances, period.
Rob, we're coming up on an hour and a half here, so I want to try and get through the remaining questions that I can. But Rob, if you have the ability to, I don't know if you can click on that link so that we can actually see the website that you're directing us to, the AssetProtectionTraining.com/plan. If you can bring that up on your screen, maybe so people can see it.
Hold on, just a second. Oh, right there?
There you go. That link right there, yeah. And that should be in the chat box because I can see it on my screen. Are you still there, Rob? Did we lose you?
Yeah. No, I'm here. Tony, that is what, look, unless you guys have a really complicated life and really complicated problems, their solution there will get you where you need to be. And get a little bit of tax help from a local CPA, or read or watch some of the videos I've published. They answer all the tax questions. If you're careful and read, you can handle it all yourself. You don't need to go broke doing asset protection, but for heaven's sakes, do it. Don't get in gridlock. That's the kind of bottom line message I want people to have. Don't get into gridlock worrying about the minutia. If you get expert advice, you won't have to worry about the minutia. But you're better off being protected at 80 or 90 or 95%. 100% is great, but 95 will put off most creditors.
One of the questions Phyllis asked was if you have an LLC owned by Roth, can you open a foreign LLC and move the Roth overseas?
The answer is I've never, ever, ever, ever done it. I don't do anything but what I'm good at, and I limit myself to my little teeny baby niche because I can be good at it and be good on a cruise ship or in Paris. But the answer to that question is yes. Ryan Fowler, who is a member of the faculty at Asset Protection Training, regularly does that for clients of law firms he represents. And the law firms bring their clients to him because he's got a little niche where he's good at that. I don't do it. I don't know how to do it. I think the price is about $4,000 to $6,000, and that's all I know. But it's very feasible to do, and I've had clients do it, and I'll be happy. The ones that did it have been happy.
And Phyllis also asked if can you get generic paperwork to create a do-it-yourself trust and LLC from Mayfair?
You can hire Mayfair, and they will prepare documents for you. They will not give you generic asset protection documents. There's no such thing as generic, by the way. They won't give you these really sophisticated, wonderful documents for you to take to some other trust company. They will only give them to you when they've been hired. Now, they're willing to be hired for $100 and give you the documents, and then if you decide not to hire them, they will write you off. I don't think they've had anybody ever do that to them, but they are willing to put their money where their mouth is and do the work without making you pay until you've seen your documents. They don't want to work with people that are just playing them, though, and I don't want to work with anybody who's playing them.
Great. This is a real easy question, but we don't have an answer for it. And Bonnie wants to know when is our next cruise ship training, so we'll have to think about that and plan it. Abdul asked about. He said he sold an out-of-country property, and I won't give you the exact number, but let's say it's under $500,000, and wants to know the best way to protect and transfer to the USA.
Well, so Abdul's turned his property into money. Abdul,
Right.
Money's the easiest thing to protect there is. Real estate, you can never get more than 80 or 90%. With money, you can come awfully close to 100%. You put an asset protection trust together, you have it own an LLC, you have it own a bank account in a country of your choice with a bank of your choice. You put your money in that bank, and you sign that bank account on behalf of the LLC as its manager. Your creditors cannot get to that money without spending more than $250,000, I guarantee. They will spend more money than you're talking about just to get to it.
And then he also asked where to invest in the USA, but I don't believe that's really a question for this webinar. But I'd also like to ask Mr. Stanton, if you're still on the line, would you just type a question into the chat box? Because if you're here, I'd like to answer your questions. And if not, then we're going to pass on that. And the last question, Rob, you covered this earlier, but this is a little bit different of a twist on it. It's about bear shares. And Alston asked, can you use bear shares and have a bank account in different currencies?
Yes, you can have a bank account in different currencies, and yes, you can use bearer shares. The problem with bearer shares is they have to be owned by somebody, and lawyers aren't stupid. They finally figured out what bearer shares are. You're better off having your bearer shares owned by your LLC, and it is still feasible in 3 countries that I know of to use bearer shares. It's a very powerful vehicle because it lets you, for those of you who don't know, bearer share companies are owned by whoever has the stock certificate in their hand, and you can transfer it. You can go to lunch with your neighbor, and you can transfer the stock certificate to your neighbor, and now your neighbor is, the guy who's holding the stock certificate, it's the new owner. It's kind of rinky-dink, Most countries are getting away from it. Most countries that are allowing it are requiring the lawyers to create them, to create verifiable documentation that the government can look into as to who the owners are. I don't favor bearer shares anymore, but I still have many clients who have bearer share entities floating around. But don't think you're going to get much protection from bearer shares. It's much better to have the shares owned by the trust, so you can say, hey, look, I don't own it. It's owned by an offshore trust. And then if worse comes to worse, and they litigate offshore with the trust company, then you can move it to another trust company in another country just by moving the share certificate. It's very, very nice thing to have, but it's not something I rely on.
Great.
That was
All right,
kind of a
so
long-winded answer, but I think that that's a good answer.
thank you, Rob. So we're gonna wind up here. We're past the 90-minute mark. If there are any last-minute questions, we'll take one or two at the most. Go ahead and type those into the chat box now. In the meantime, if you haven't yet taken a look at it, I would encourage everyone to go to that website, AssetProtectionTraining.com /plan, and just take a look at what's being offered there. I think you will be shocked and delighted at what you see. And then for everyone that's on here, Rob mentioned that you are going to be invited back to the next webinar in November, and there is going to be no charge to attend that. There may be a fee for new people that come in, because this was an opportunity where Rob was actually inviting everyone to come into something that he normally does just for his advanced members, who are part of a monthly membership for advanced asset protection training. But just because you were here today, you're going to be invited again for free. So that's awesome. Please plan to join us on November 21st as Rob and a special guest talk about how to attack an asset protection plan. So here is a couple questions. What is the process for placing assets in, and the question is not complete. I'm sorry. Do you have to report offshore accounts to the IRS?
Yes. 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 And if you don't, you're sunk. Don't mess with it. Don't mess with Uncle Sam there.
But reporting them is not necessarily a problem, because when they're offshore, even though they're reported, they are much more difficult for the IRS to reach than if they were reported accounts in the U.S. Is that correct?
Oh, no, the IRS, no country in the world automatically enforces other countries' judgments, but you can even go further and say no country in the world enforces U.S. tax laws or tax bills or tax judgments. The United States made a choice to not enforce a French tax judgment. The government of France, a long time ago, over 100 years ago, asked the United States to get them some money from one of their citizens. The United States says no. Ever since that time, neither the United States nor any other country will enforce another country's tax judgments. So for just normal income tax, your money is probably safe offshore, even if you owe a whole lot of money, because it's virtually impossible to get to. That doesn't mean that the IRS won't harass you until you're blue in the face, but it means that your money still will not be reachable by them. And it's even stronger with tax judgments than it is with normal civil judgments, like a slip and fall or slander or breach of fiduciary duty, those types of lawsuits.
Great. Rob, okay, I'm going to ask one more question, and then I'm turning it back over to you to close as you wish. And this comes in from Michael, and Michael asks, what is the process for placing assets in a trust, such as real estate and a recreational vehicle, an RV?
Simple. It's just transferring title. Real estate, if you wanted to put it into a trust, and trust wouldn't be the normal thing we'd put it into. If it was domestic real estate, we'd put it into a domestic LLC. And if it was offshore real estate, we'd probably put it into an offshore LLC, and then have those LLCs owned by your holding company LLC, the one under the trust. And you do it by simply doing a deed. If your LLC, that's, by the way, all of your real estate each piece of real estate should be in its own entity. That's Rob's rule number 11. Divide and conquer. Always divide and conquer. Never mix your income and liability generating assets. But say you had 11 pieces of real estate, you'd have 11 LLCs. If they were in the United States, you could have them owned by your offshore LLC. If you had them in France or any other country, you could have the LLCs owning those pieces of real estate owned by your holding company too. All it is a matter of doing a deed to the LLC and having the membership interest in the LLC owned by your holding company LLC. No brainer.
And Joseph Jack just asked us to recognize his presence during the webinar, so there's a shout out going out to Joseph Jack.
Hi, Joseph.
And Rob, one other question. I know I said there would be one more, but Robert asked that he doesn't understand how forming an LLC under the trust gives you control of the trust versus the trustee. And I know that you went through that in the diagram, but is there a quick description that you could explain that to? And why can't that process be done in the U.S.?
It can be done in the U.S. and you need to watch the replay. First of all, that's the real answer. But the other answer is you manage the LLC because the LLC document that creates the LLC and has all the rules that the LLC operates under says that it is a manager-managed entity, and you are declared to be the manager. You could have your neighbor, you could have me be your manager if I was willing to do it. You could have Rob Lambert be your manager. That means Rob Lambert signs the bank accounts. That means Rob Lambert opens the bank accounts. It means I manage the LLC. The manager is in control of the LLC, not the trustee, not the owner. That's the key. It's manager managed, not owner managed. I hope that was helpful.
Yes, that's great. Well, that's all I have, Rob.
Okay.
Thank you.
And by the way, I don't know who Joseph Jack is, but it was a good comedic break. Guys, I want to thank you for coming. I'm very interested in whether this was helpful. I'm really interested in what you guys thought about this. I'm, as you know, really sensitive to what people ask, and I'm passionate that you all need to protect yourself. I don't care where you go or how you do it, but don't let the end of the year come without you doing something to make your family safer. That's about all I've got to say today, and I'm going to go swimming.
All right, excellent. Thank you, Rob, and thank everyone for attending.
Bless you all, and thank you all.